మీకోసం ఒక అద్భుతమైన జ్యువెలరీ కొనుగోలు అనుభవం ఎదురుచూస్తోంది. మలబార్ గోల్డ్ అండ్ డైమండ్స్ వారి డాలస్ షోరూమ్ లో 20 దేశాల నుంచి 30,000 విధాల ప్రపంచంలోకెల్లా ఉత్తమమైన జ్యువెలరీ డిజైన్ల అనుభవాన్ని పొందండి. $1,000లకు మించిన డైమండ్స్ అండ్ ప్రెషియస్ జెమ్ జ్యువెలరీ ఆభరణాల కొనుగోలుపై ఖచ్చితంగా పొందండి బంగారు నాణేలు. జనవరి 29 వరకు మలబార్ గోల్డ్ అండ్ డైమండ్స్ ని డాలస్ లో విజిట్ చేయండి. ప్రపంచ స్థాయి జ్యువెలరీని కొనుగోలు చేసే అనుభవాన్ని పొందండి. Malabar Gold and Diamonds now open in Dallas.
గెలుపే ఊపిరిగా, పట్టుదలే ప్రాణంగా, ఆశయమే గమ్యంగా పోరాడే యోధుడికి విజయం అన్స్టాపబుల్. ప్రశ్నల్లో మరింత ఫైర్, సర్దాల్లో మరింత సెటైర్, మీకోసం మరింత రంజుగా. దెబ్బకి థింకింగ్ మారిపోవాలా? మీకోసం మరింత రంజుగా.
अब तू देख लेगा बच्चन साहब का खेल.
డౌన్లోడ్ ఆహా నౌ.
ఆకర్షణీయమైన చీరలు, అప్పురపరిచే ధరలు, అందరికీ నచ్చిన, అందరూ మెచ్చిన షో మన లక్కీ మహిళ. బోలెడంత ఎక్సైట్మెంట్, వండర్ఫుల్ విన్నింగ్ మూమెంట్స్.
ఎగ్జాక్ట్ చెప్పారు, మీరే గెలుచుకున్నారండి. కంగ్రాచులేషన్స్. $220.
సెలబ్రిటీ హోస్టులు, అదిరిపోయే పంచులు, సరదా సరదా కబుర్లు.
ఆశ దోశ అప్పడం బడ హెల్ప్ మీరు ఆడుతున్నారు.
ఇలా మరెన్నో మెమరబుల్ మూమెంట్స్ తోటి 3rd యానివర్సరీ జరుపుకుంటోంది మన లక్కీ మహిళ. Watch it live only on TV Asia Telugu. మీ అందరికీ 3rd యానివర్సరీ శుభాకాంక్షలు.
మీకోసం ఒక అద్భుతమైన జ్యువెలరీ కొనుగోలు అనుభవం ఎదురుచూస్తోంది. మలబార్ గోల్డ్ అండ్ డైమండ్స్ వారి డాలస్ షోరూమ్ లో 20 దేశాల నుంచి 30,000 విధాల ప్రపంచంలోకెల్లా ఉత్తమమైన జ్యువెలరీ డిజైన్ల అనుభవాన్ని పొందండి. $1,000లకు మించిన డైమండ్స్ అండ్ ప్రెషియస్ జెమ్ జ్యువెలరీ ఆభరణాల కొనుగోలుపై ఖచ్చితంగా పొందండి బంగారు నాణేలు. జనవరి 29 వరకు మలబార్ గోల్డ్ అండ్ డైమండ్స్ ని డాలస్ లో విజిట్ చేయండి. ప్రపంచ స్థాయి జ్యువెలరీని కొనుగోలు చేసే అనుభవాన్ని పొందండి. Malabar Gold and Diamonds now open in Dallas.
గెలుపే ఊపిరిగా, పట్టుదలే ప్రాణంగా, ఆశయమే గమ్యంగా పోరాడే యోధుడికి విజయం అన్స్టాపబుల్. ప్రశ్నల్లో మరింత ఫైర్, సర్దాల్లో మరింత సెటైర్, మీకోసం మరింత రంజుగా.
Telugu. We have with us our special guest Emily. She's an immigration expert, an eminent lawyer and partner at Reddy and Newman law firm based out of Houston, Texas. A hearty welcome to the show, Emily.
Thanks so much for having me, Sita.
Amazing. So I just wanted to mention a special note and special thanks to our show sponsors, Malabar Gold and Diamond, they have launched their 300 store in Dallas. I hope you all get to visit their store, be dazzled with their unique jewelry collection. And also a special thanks to movers.com, our one-stop solution for moving needs, and AHA OTT, who is entertaining us with their amazing shows and movies. So you can watch us live on Yup TV, YouTube, Sling, World TV. This is our 3rd anniversary on the talk show, and we are immensely grateful to Rahul Garu and Emily for being a great support in this whole process. As we jump into the question of the day, Emily, just wanted to understand more about the H-1B lottery winners. Is it possible for them to switch their employers before the October 1st? And given the current job market, is that even a feasible option?
Yeah, there may be an option for that depending on the situation. So we're about 20 days into the filing window. People that were selected found out at the end of March, and the filing window opened April 1st. That'll stay open until June 30th. For those who have already received the approval or will be receiving the approval over the coming months, the question always comes in, what happens if I need to change jobs? We haven't crossed October 1st yet, which means the H-1B technically hasn't kicked in.
Yep.
So there are a couple of ways you can address the situation. The safest way in our experience is to actually wait until October 1st. If your employer that sponsored the H-1B is not going to withdraw that approval notice, wait until October 1st and then immediately file a transfer on October 1st. And then you can start working with the new employer from that point going forward. It gets a little trickier if you're trying to file before October 1st because you're afraid maybe the company might withdraw your approved petition. Because in the past, USCIS has said, until October 1st, you technically haven't been counted in the cap yet. You only get counted when you get selected and approved and the change of status actually takes effect if you're in the US. So in the past, they have actually denied a change of employer petition that was filed before October 1st on the grounds that you're not counted in the cap yet. We haven't seen that happen in every case. There's been a number of cases where we went ahead and filed before October 1st because we really didn't have an option. We were afraid the H-1B would be lost if we didn't. And some of them worked out. Some of them were approved. Some of them have been denied in the past. So there's very inconsistent in how that is applied. But that would be one way to move forward. The safest way is to wait until October 1st and file that transfer. And the question comes up if you're in the US and you're already working, maybe you're on F1 with OPT or you're on H4 EAD, what happens if you lose that job and you start working for the new employer before October 1st? You actually can do that because you have your EAD that allows you to do that. The main thing is to make sure that the previous employer isn't going to withdraw if you're going to do that, so that if you can negotiate with them, please wait until the end of October to withdraw the approved H-1B so I can safely transfer to another employer. That's the best route forward.
Awesome. That is very good to know, and there's a great news for a lot of our callers if they're in this boat of switching their employers prior to the cutoff date.
Yeah, it's been a common issue that comes up every year between April and October. So we've definitely had to deal with that situation quite a bit.
Great. This is a great piece of advice, and I hope a lot of our callers get benefited out of this information that you have shared. So on that note, Emily, probably we can take our first caller in. The first caller here we have is caller ending with 95449.
Hello.
Yes, ma'am. Please go ahead with your question. We can hear you.
Yeah. Actually, I have two questions regarding the 485 filing. My priority date is September 2014. So we have filed a 485 in October 2020 in EB3 downgrade, and also filed a new 485 in EB2 in July 2022. We received a notice from USCIS to appear for an initial interview. So my first question is, what can I expect in the 485 interview?
So, and when you looked at the interview notice, was it for your EB2 filing or the EB3 filing?
EB3?
EB3, okay.
Sorry, EB2. Sorry,
This is the
EB2.
Okay. Okay, so the main thing at the interview, you want to bring an employer letter of support or a newly signed Supplement J. Are you still with the same company that sponsored you?
Yes.
Okay, so you'll either want to bring a letter of support.
Yeah.
Okay, you'll bring a letter from them or the Supplement J form. Either one of those is fine to confirm that the job offer is still available to you. We also recommend bringing your last 3 years tax returns and your last 3 years W-2s and your last 3 pay statements. And beyond that, are you married? Do you have any dependents that filed with you?
Yes, yeah.
Okay, and so for your dependents, for your spouse, you'll want to bring proof of a valid marriage, so documents showing that you both use the same address, bank statements that show your home address on them, mortgage paperwork or lease that have both names and those sorts of things, birth certificates for children. The interview itself generally goes through the I-485 application form. So you'll want to get a copy of that if you don't already have it and review everything that was filled out on that form to make sure it was accurate when you filed it. And then just be prepared to answer any of the questions that are on that form. It's usually just basic information that they're looking into, name, birth date, where were you born, parents' names, when did you get married, where were you married, those kind of basic things, verifying your current address. And then asking a lot of the yes and no questions. There's about 6 pages of them on that 485 form about whether you've ever committed a crime or are you a terrorist, are you a communist? All of those questions, review them so you're familiar with them so you don't get caught off guard by them, but they do ask a lot of those. And then otherwise they may just verify your last date of entry, how you entered last, if it was on H-1B or was it on advanced parole. You want to bring your EAD card and your advanced parole with you, the originals, bring your passport with you. And if it's just a basic employment-based green card interview, that's going to be most of it right there. If you've got any issues in your past, the company has maybe had some issues before, then it can be more involved where they might be asking about more about your job duties, what you're doing, if you're working at an end client versus direct employment. They may ask how you got the job, who hired you, and that sort of thing. So it really depends on if it's just a basic interview or if there's some reason behind it because of some past issue with the company or past immigration issue or past criminal issue or something like that.
Okay, ma'am. And one more question, ma'am. As we have both 485 EB3 and EB2, and they are pending with USCIS, is there any possibility of USCIS asking us to withdraw EB3? And if they ask that question, how should I respond? Can I say I don't withdraw neither of them?
So typically when the date is current for one of them, they will ask you that question when you're called in for an interview. We don't see them ask that when the date is not current, because at this point you don't know whether your EB2 case is going to become current first or the EB3. But if they do ask that at that time, you can just let them know at this point, I don't intend to withdraw either of them because I want to wait and see which priority date becomes current first. And if they hassle you about that or give you a hard time about it, you can ask them to mail you a request for evidence, giving you the ability to respond to that later. So you don't have to give an answer right then and there. You can work with an attorney to decide how you want to best answer that type of RFE. But most likely they shouldn't ask that because the date's not current. They're not able to approve one or the other at this point.
Thank you.
Thank you. Thank you for taking the call. Thank you.
Thank you. Good luck. Let's take our next caller here. Caller ending with 6835.
Hello.
Hello. Yeah, we can hear you, sir. Please go ahead with your
Hello.
question. Yes, sir, we can hear you.
Yeah, hi. Actually, I'm on H1, and my client, he is planning to hire us on EAD because I have green card EAD also. But my consultancy company somehow came to know about that. Will there be any issues if I move on to, the client using my green card EAD?
You mean if the old company finds out about that?
My current consultancy company, which holds my green card processing.
Has your 485 been pending for over 180 days?
Yes.
Okay. So, and obviously you're doing the same job. So you qualify for AC-21 to allow you to move your green card application with you to any new employer. In this case, it happens to be the client. So there's nothing from an immigration standpoint that company can do. Even if they were to retaliate and withdraw your I-140, for example, because your 485 has been pending for 180 days, I'm assuming your I-140 is already approved at this point. Having them withdraw your I-140 has zero impact on your 485. So even if they were to do that, you'd still be fine. You can move the green card process with you to the new employer. You can have them submit the supplement J. From a employment standpoint, you may want to look if you had to sign any employment agreement or contract with your current employer, review what the provisions are on that, if there's any kind of restriction of you being hired on by the end client that you've been working with. But from an immigration standpoint, there's nothing that can harm you if you were to make that switch.
Okay, got it. So actually during this process, I may have to, without a job for some time because the client that's saying it might take some time. I may have to go out of the job because I'm currently on H1. If I lose my job, how can I make my status to 485 pending because I have been on H1?
So that there's nothing that you actually do. It's just a matter of once you stop working for the H-1B employer, from that day going forward, you're no longer on H-1B, and instead you're relying on your adjustment of status, and you can begin working for the new employer on the EAD. Now, the difference with the EAD does not have a 60-day grace period like the H-1B does. That being said, the EAD and the adjustment of status, in order for that to be continue to be valid, you just have to have a job offer waiting for you. So if you do have to stop employment for some time between leaving this current employer and joining the new employer, as long as the new employer has offered you that job and you intend to take that job, that's fine, even if you have to stop working temporarily right now, because the whole process is not based on actual employment while it's going on. It's based on the offer of employment that you'll take when you get your green card. So as long as they're still offering you the job during that break, you should be fine.
Okay, got it. Thank you so much, Emily. Thank you for your time.
Thank you. So here we have the next caller ending with 6255. Hi, this is the caller ending with 6255. Please go ahead with your question.
Hello. Hi. I'm on H1 and my I-140 is approved and its priority date is July 2017. So the question is, my wife has H4 EAD and H4 approved, but we went to India and came back on H1. She came back on H1. Now can she move back to H4 by going out of the country and getting again stamped and use the H4 EAD?
She can, yeah. So the H4 EAD, even though she's entered on H-1B since then, it's still valid, assuming it has not yet expired. So if she gets back to H4 status, she can just take up that same EAD and continue working. There's actually 3 ways she can get back to H4 status. One is filing the change of status to H4, which I don't recommend because the processing times take forever. The other is, as you mentioned, is she exits again, going for H-4 stamping and then coming back. But the third option, and probably the easiest option, is what, if you've heard Rahul before, he always talks about the margarita switch. This is if she now exits to Mexico and just does a short weekend trip there. When she's coming back into the U.S., she does not need an H-4 visa stamp in her passport. She would instead show her H-4. I'm assuming she's got an H-4 I-94 from before. So she would show that H-4 I-94, show your H-1B approval notice, bring the marriage certificate, and she can be admitted into the U.S. back in H-4 status without actually having to go for stamping. So that would be an easier third option to consider.
Oh, okay. Thank you. That's all.
Thank you so much. That's a fabulous way to resolve this issue, I guess. We have the next caller ending with 9849.
Hi, good morning. Hello, sorry, good afternoon. Thanks for taking my call. So my priority date is 2014 October, and I received my green card last year when it was current. So I'm traveling to India coming next month. So do I have to carry any other documents apart from my passport and the GC and the permanent residence card?
That is all you need. I'm sure you're used to always having to carry your approval notices, your I-797s, and your pay statements, and a letter from your employer. You don't need any of that anymore. All you need is your passport and your green card.
Oh, excellent. Yeah, thanks for the time, Emily. Yeah, appreciate it. Bye.
Thank you so much. Let's take our next caller in. Okay, let's take a quick question. Yeah, I think we have the caller, and we'll take the caller and then take a question here, Emily. The caller ending with 8549. Hi, this is the caller ending with 8549. Can you please go ahead with your question?
Hello.
Yes, sir. Please go ahead.
Hello. Are you able to hear me?
Yes, sir. We can hear you.
Yes. Can I ask my question?
Please go ahead, sir.
Yeah, 1 second.
There could be some lag if you're hearing us on YouTube. Or please go ahead with your question.
Yeah, I stopped YouTube. That's what I did. I hope you're able to hear me well.
Absolutely.
Okay. Now my query is, okay, I'm already on green card. Okay. My wife and my daughter is in India, but I didn't apply for green card for them together. So now I have actually initiated a process to add them to the green card process. So I'm just trying to understand if any help you provide on this, like you can, my query is like, yeah, I'm not able to go to the next step. I'm not sure what to do. So I'm just trying to understand if you all provide any help on getting my family back here, right? It's more like a family-based visa. Yeah.
So what was the reason that they didn't file along with you?
Because they were not here. My wife was working in India, and so I filed an EB-1. Okay, so in 2018, I got it in 2020. So that 2 years they were not here due to some personal reasons. They were in India, so I couldn't apply for them.
Okay, and so you said you got your green card in 2020?
Yeah, 2020 I got my green card. Yeah.
Okay, so and are they still outside the U.S.?
They are not in US, so I'm trying to bring them. So I went through another attorney before, and they did one step for processing. Now currently it's with NVC, National Visa Center, for doing the DS-261. But I'm not able to proceed with the DS-261 and 260. That's where I'm stuck now.
So are you logging into the CEAC system at ceac.gov?
Yeah.
Okay, and what is the
Yeah.
issue where you're not able to fill out the DS-260s for them?
So the issue is like when I give the application number and the NVC case number and the last name and they go inside, I can see their details. But it says DS-261 where it is saying third party assignment, that is incomplete. It's not saying start. Okay, it says incomplete. When I click incomplete, it again comes back to the login page again. So it keeps moving this way. So I even raised a query with NVC and they don't have a call center, unfortunately now. They stopped. So I tried raising, they're not understanding my question. They're asking me what error we are facing and I'm not facing any error. It is just, it's like a technical issue. So what I wanted to ask here is there a way I can do this manually, like by filling a form and submitting it to NVC instead of doing it online?
No, they only do the
261
online DS-260 process, unfortunately. So I would recommend trying every different browser you can think of, incognito, Chrome browser. That CEAC system is very glitchy. So we do see that. If you're still having that issue, you would have to, again, use that public inquiry email address for the NVC and maybe include a screenshot of what you're seeing. And ask them to give your dependents access so that they can complete the DS-260.
Yeah. See, I did 3 times already the query. I'm doing this from February this year. I was able to reach them. They are replying, but they're not understanding because I'm not able to explain, I think, to them. Even I wrote like a big email and everything on the CEAC site and public inquiry. So what I'm trying to understand, is there any other alternative way I can reach them or I can go through attorney? I'm fine to pay the attorney or like, so if I can do something like through a different way or I can visit their center or something in person.
An attorney can help, but they have to do it through the exact same way. But they might be able to phrase the question more clearly or contact them. I mean, I've dealt with this on my cases as well, and it is a hassle. It's a lot of just getting the runaround. You just have to keep following up with them and asking the questions. But yeah, you can work with an attorney to help guide you through that. Maybe they're just not understanding what the issue is or what your question is. But unfortunately, there's no other way to contact them. No, there's no other way to contact them.
There's no other form I can do a printed form or anything, ma'am?
No, they don't accept that. No.
Oh.
Yeah, it's a pain. I definitely understand, but yeah, you have to go through that process.
Okay. And your firm also helps with it. If I can come to you, or is there a way I can get that help from the attorney?
Yeah, you can send us an email at info@rnlawgroup.com and we'll get you in touch with an attorney that can help with that.
Okay. I don't need to go for a consultation for this, right? I just need a help in the background to help me to get this started.
You can just reach out with us first and then one of our team will get in contact with you and discuss the process and take it from there.
Okay. No problem. I'll do that. Thanks a lot.
Yeah.
Okay. Yeah. Appreciate your help. Thank you.
Thank you so much. Let's take our next caller here.
Hello.
Yes, please go ahead.
Can you hear me?
Yes, sir. Please go ahead.
Thank you. Hi, I have 2 questions, and this is regarding I-140. So currently, my employer is not sharing the I-140 approval documentation, but he has shared the soft copy, and haven't yet completed my 6 months of period of time with the employer. So in this case, can I change employer? Is it something irrespective of that completion of the 6 months? Can I change the employer? If so, what is the documentation that is needed at this point of time if I want to change the employer? Is it the soft copy will be enough?
Yeah, soft copy is all you need. You never need to get the original of the I-140 approval. But so where are you at in your 6-year limit? Are you an H-1B?
Yeah, I'm in the 7th year extension. Yes, H-1B. Yes.
Okay, and do you have a previous I-140 approval or is this your first I-140?
This is the first time.
Okay. Okay. So technically, yes, you can change employers, but before the 180 days hits, you run the risk of your current employer withdrawing that approved I-140. If they do that, that means you can no longer use that I-140 to get extensions with any other company. So that's kind of a big risk there. So if you are going to change employers, you may want to work it out with your current employer first to make sure that they won't withdraw your I-140 before 180 days, because if they will, you are going to be stuck. There's no way you can get a new perm, a new I-140 in place in time for your next extension. So it's a very big risk to move right now if they're going to withdraw.
So meaning, suppose after 180th day, we can transfer immediately irrespective of that request. So
Correct.
They cannot have the chance to revoke. Okay.
Correct. Once it crosses 180 days, they can still withdraw it, but you can keep using it to get extensions of your H-1B with any other employer. So the withdrawal doesn't impact you. You still keep that priority date. You still have to go through new perm and new I-140 with your new employer, but you can keep using this old I-140 to keep getting extensions until your priority date becomes current.
Okay, even though they can revoke, but still I have a chance after the 180 plus days, I can apply with another employer. It doesn't
exactly
affect me.
Right.
Okay. Another question, please. So I have employer A and employer B, and employer B is a concurrent H-1B. And if I travel to India at this point of time, and the main employer A is with I-140, which I'm having with, and employer B is a concurrent H-1B. And if I travel to India, and if I want to face the embassy, because I have to face the embassy now. So in this case, what happens? Can I go and face the embassy, or what, do I need to come back? Or for which employer do I need to represent as a primary employer? Of course, as A. Can I also need to put the information of employer B in the DS-160 form?
So you do need to list that employer B in the job experience section. It's a little tricky because the way the DS-160 is, it only lets you list one current employer. So you're going to have to fill out company A as your current employer, and then the next position will be company B, and list the start date, and you'll have to put the end date, like the day you're filling out the DS-160, because there's no way to say to present. And then you put the rest of your employers after that. And then you'll go for stamping for A. The difficulty with these concurrent filings is we don't have any guidance from USCIS about what happens, because you can only go for stamping for one company, and you're only entering on one company's visa. So after you enter, there's no guidance from USCIS about what happens to your concurrent employment with company B. So for that reason, as being extra cautious because there's no guidance, we recommend that after you re-enter on company A, if you still want to keep working for company B, have company B file another concurrent petition going forward from that point.
Okay. So one thing I want to make sure. So when we are filling in the DS-160 form, you are suggesting me to fill the primary employer A information and the next as a employer B information. Is that correct?
Exactly.
In the experience? Okay.
Right.
Irrespective of the the current dates, whatever I'm working in the parallel. So that does not have any impact. Okay.
Right. Yeah, because there's no way to put both employers on the form properly.
Okay, sure. Thank you. Thank you so much. Thanks a lot. I'm good. Thank you. Thanks for your time.
Thank you. Let's take the next caller. Caller ending with 6626.
Yes, can you please hear me?
Yes, sir. Please go ahead with your question.
Hello. Yes. So my question is, I have a 485 pending with employer A, and I have used AP to travel. Currently, I'm working for employer B on H1, and employer B has filed I-140 in EB3. So my question is, when can employer B file 485 when I'm on a parolee?
non-immigrant status, or do I have to be on the non-immigrant status?
Right. Yeah. So, and we don't have any guidance on that. And so in order to be on the safe side, since you last entered on the AP, and we only recommend this for people who are planning to file another 485, is to use that margarita switch or automatic revalidation, travel once to Mexico, and when you're coming back in, show your I-797 approval with the I-94 for employer B so that you can be admitted again in H-1B status, and then you can file the 485 with employer B.
Sounds good. So that will put me back in H1?
Correct.
If I use the visa, okay, cool. Would you recommend travel by air or land to get the updated I-94?
I always recommend air for that because with land, not every CBP officer is going to issue you a new I-94 when you're coming back in, versus when you're flying by air, they have to give the new I-94. And that's the whole purpose of your trip, is to get the new I-94 listing H-1B as your current status.
Sounds good. One last question. How long is it taking these days for the I-40 approvals under regular process?
I-140 approval?
Yeah.
I would say anywhere between 3 and 10 months. You do have the premium processing option, but it's a very wide range right now.
Got it. So one last note. One question I have is that when I entered the parole, it was given for 1 year, but my H1 is beyond the 1 year expiration of AP. So I should be fine, or do I need to file an extension?
Yes, that's totally fine. Yeah, no problem at all.
Okay. Got it. Thank you so much for answering the question.
Thank you so much. Thanks for your all these great advice.
Given for 1 year, but my H1 is beyond the 1 year expiration of AP.
There could be some lag while you're listening to us. Let's see caller ending with 7. You could mute us on YouTube and probably listen to it later, sir. We are going to take a question. I see caller ending with 3747. Do you have a question for us?
Yes. My question is like this, okay? I have my 485 interfiled, okay, in November 2020, basically downgrading to EB2 to EB3. And basically I received my EAD and AP on February 2022. After that, my EB2 dates were current, okay, in June 2023. And we have filed the 485J, okay, at that time. And after that, they sent a RFE for EB3 I-140, which was also approved in 2023. So still I'm waiting for my green card to be issued at this moment. I'm managing my H-1B, and which is valid until 2024. So I just need some kind of guidance, should I have to extend my H-1B next year, or should I go to and use my EAD and AP? And if I use that, okay, is it considered, then I can switch between the EB3 and EB2 or not, when the dates will be current in that case, or it doesn't matter because already my...
Yeah, your EB3, you said it had an I-140 RFE, but then it got approved, is that right?
Yes, so I have both the approved EB2 and EB3 I-140 approved at this moment.
Okay. So when you filed in November 2020, that was downgrade with an EB3 I-140. That I-140 got approved, and then you did the supplement J to upgrade the EB2 last year?
Correct, when the date was current.
Gotcha. Okay. So, it is relatively safe at this point to forego the H-1B and use the EAD and AP going forward. Because the biggest risk to most employment-based 485s, the biggest reason for denial is the I-140 getting denied. So you've already crossed that hurdle twice. You've got 2 I-140s approved. So there's really not a lot that goes wrong with the 485 from that point. The H-1B, you keep extending that. We never know who the next president's going to be, if it's Trump again, and we have all these short approvals and denials and all of that all over again. There's just a lot of risk with the H-1B, and you have to go for stamping when you travel and all of that, compared to the EAD and AP, which is much easier for you to comply with. The one thing that is a bit of an issue right now, if you do decide to forego the H-1B, is the long processing time for advanced parole. So I know you mentioned you got your EAD and AP approved last February, so I'm assuming that's good till February 2024. If you forego the H-1B and you go to renew your EAD and AP, as long as you file your EAD before the current one expires, you get the automatic 180-day extension of your EAD. Right now it's 540 days, but that's going to go away later this year, so it'd be 180 days. That's usually plenty of time to get the EAD approved before you run out of employment authorization. AP does not have any kind of auto extension. So if you get to a point where your AP has expired and the new one is pending, you no longer have your H-1B, and then you have an emergency need to travel, that's where you're going to be stuck. So you can always, apply for an expedite of that AP, but it's very hard to get that. They don't always approve everybody. So that's right now, just based on current processing times, that's the biggest risk if you choose to forego the H-1B and utilize the EAD and AP. If you feel confident that you're not going to have any unexpected travel, then you might want to just go ahead and use the EAD and AP going forward.
I hope that clarifies.
Hello.
Yes, sir, we can hear you. Please go ahead.
Yeah, I'm not able to hear anything. Okay, fine. So my follow-up question was once I will go to the EAD and AP, at that point of time, I'll be able to choose between the EB3 and EB2, whichever date is current or not.
Yes. So the only difference is if you wanted to change categories by filing a second 485, you lose that option, but you can still move between EB2 and EB3 using the same 485 by going through their current process of submitting that supplement J form. So yes, you can. If you're in EB2 now, then when the date becomes current in EB3, you can submit the supplement J to downgrade back to EB3 in the future, even though you're no longer on H1.
Got it. Okay. Thank you very much. Okay. For help.
Thank you so much.
Yep.
We have a few more callers online. Let's take the next caller. Caller ending with 2847.
Hello.
Yes, sir. Please go ahead with your question.
Yes, ma'am. Thanks for pick up my call, ma'am. I have question regarding. I recently received my permanent I-140. My priority date will be. It is June 2022. Yeah, my question is, if I change the employer, is there any effect in my H-1B?
Has your I-140 been approved for 180 days yet?
Not yet, ma'am, but I'm not yet. It will be complete by September, ma'am.
Okay. And how much time do you have left on your 6-year limit?
My 6-year limit already means it will be complete next month 12th, ma'am. May 12th it will be complete my 6 years limit.
Okay. So in that situation, you basically need to make sure that this I-140 does not get withdrawn before 180 days. If it does, then you have no way to extend your H-1B any further. So it's not a great time to change employers right now, unless you're confident that your current employer that has that I-140 will not withdraw it before it hits 180 days. So if there's any risk that they'll withdraw, you would want to stay with this company until it hits 180 days. Then once you transfer at that point, you can use this I-140 to get a 3-year extension and keep getting those 3-year extensions with any employer going forward until your priority date becomes current. If you're married, your spouse can use this I-140 to get the H-4 EAD. You get to keep that priority date, even if the company does withdraw the I-140 after 180 days. You'd still have to go through the perm and the I-140 process again with your new employer in the future in order to actually receive the green card. But you can keep using this I-140 to extend your H-1B, get your spouse's H-4 EAD, as long as it's not withdrawn before 180 days.
Okay, got it, ma'am. If after 180 days, what is the best time to file my permanent I-140 for the new employer, ma'am?
So assuming your country of birth is India, you have time because with the 2022 priority date, it's not going to be current anytime in the near future unless there's a change in law or policy. So basically you can keep using this old I-140 to keep getting extensions until your priority date does become current. So you need to have the new perm and I-140 in place with the new employer by the time your priority date becomes current. But all the time that's in between, there's no need for you to get that new perm and I-140 in place.
Okay, and is there any, for this case, means there is no restrictions for extending my H-1B number of times whenever my priority date will be current. Up to that time, I can extend any time, any number of times, right, ma'am?
Right, as long as it's been 180 days and the employer has not withdrawn during that time.
Okay, ma'am. Yeah, if they withdraw, means after 180 days, what will happen, ma'am? Is there any impact on that H-1B extension?
Nope, then you can keep extending.
Okay. Okay, thank you, ma'am. Thank you.
Yep.
For your time. Thank you. Yeah, thank you.
Let's take the next caller here. Caller ending with 8229. I see there is a caller ending with 8229. Please go ahead with your question. I hope you're able to hear us. This is for caller ending with 8229. If you're muted, please press *6 to unmute yourself.
Yeah, hello. Hello.
Hi, sir. We
Hello.
are able to hear you.
Hello. Yeah, is my voice is audible to you?
Yes, very much. Please go ahead with your question.
Yeah, I got picked in this year the lottery, madam. But my graduation is in civil engineering and worked from past 8 years in civil engineering field. But my employer was hired in IT. So can I go ahead with this process or can I keep this process?
So I heard that you said you got selected in the lottery this year, but you said you didn't graduate yet. Is that what I was having a hard time hearing.
I graduated in civil engineering. I did my graduation in civil engineering and worked in civil engineering field also from 8 years.
Mm-hmm. So you graduated with civil engineering and then you said your employer is going to file what?
And IT. My employer was filed in IT and I got picked in lottery this year.
All right. And how many years of IT experience
how can I
do you
process
have?
my application? I have 8 years of experience.
In IT?
I don't have an IT experience. I have 8 years in civil engineering itself.
Okay. And no IT experience?
No IT experience, but the IT is related to my field, like different softwares are there, like Starpro, Revit, AutoCAD. We work on different softwares in civil itself.
All right. So it has been difficult to get an approval for an IT role, software engineer or computer systems analyst, with a civil engineering degree without having some kind of IT experience or a postgraduate diploma of some sort. So unless your IT position is closely related to civil engineering, I know you mentioned some of the softwares are the same. So you really have to make sure that the job description makes it clear that civil engineering is what qualifies someone for this job, not a computer science degree. Or you're going to have to get some sort of expert opinion letter probably if you get a request for evidence. There's a very high chance of getting a request for evidence asking how your degree is directly related to this IT position. How does it qualify you for that role? It's not impossible to get an approval, but it could result in a denial.
Okay. So, yeah, this is my question.
Thank you so much. And
Thank you.
Thank you. I believe we can switch between some questions here that we have online.
Okay.
So the first question is, if my AP expiring on July 28, 2023, can I enter the US on July 25th, 2023?
Yeah, as long as your 485 is still pending, there's no problem with that at all. The AP just has to be valid on the date you're entering. It's not a problem even if it's expiring 2 days later.
So that's your answer. There is one more question here from Kushru Patel. What to do if H4 extension and H4 EAD still showing case received have not been processed with my H-1B extension? Approval is received on 4/13 via premium. It was filed together, sent in the same package. And I think there is a follow-up question. For the case ruling, what does filing together, H1 extension, H4 extension, and H4 EAD actually mean? Can you please elaborate?
Gotcha. Okay, yeah, so based on the settlement agreement, when the I-129 for the H-1B extension, the I-539 for the H-4 extension, and the I-765 for the EAD extension are all filed together in the premium processing service, the immigration service is supposed to approve all three together, and they are doing that in probably 95 to 98% of the time. They are aware that there has been some glitches with that, and there are a few cases that they approved the H-1B and the H-4 and EAD are still pending. So that has been happening. Generally, the best way forward is to have your H-1B employer or their attorney that filed the cases to email the premium processing unit and inform them that we see that the H-1B has been approved, but the H-4 and EAD remain pending. Please give us an update. Please approve. They're supposed to be approved all together. And usually that takes care of it. If the employer or the employer's attorney is not cooperating, they don't want to reach out to USCIS because they got their H-1B approval, they're not really worried about the H-4 and H-4 EAD, then it is the H-4 spouse who can call customer service. If they can't call premium processing, but they can call customer service to inquire into the status and explain that they were all filed together and that they should have been approved together. That's going to be your next best bet. If it is extending beyond another couple of days and they're not responding, litigation may be an option to force them to comply with their own settlement agreement.
Yep. I guess that is a great piece of advice. Let's take one more question here. It is, I think the question is same like cross-country chargeability where it applies dependent to primary for upgrade. The same way it applies to upgrading from EB3 to EB2 based on dependent degree, but primary is 3 years. I'm not too sure. Very clear.
No, it's not the same. So you can't rely on your spouse's degree to upgrade yourself into EB2. What would have to happen is the spouse who has the 4-year degree would have her employer file the perm labor certification in I-140 and EB2. And then if that date happens to become current first, everybody files together in EB2 based on the spouse's I-140 approval. Otherwise, you would all file together in EB3. But cross-chargeability doesn't work like that.
I guess we'll take the last question for today. Emily, the question is from Venkat. Many of my friends are getting green cards through bona fide marriage with US citizens. Does that really work? How long they have to be in a relationship to get the GC renewal from temporary to extended?
Well, yeah, I mean, there is a category called the immediate relative category for a green card, which is when a US citizen marries someone from another country, they're able to sponsor them and a green card is immediately available. If that person happens to be in the US, they can, and entered legally into the US, they can be sponsored for the 485 as well. So the US citizen files an I-130 petition and the applicant, also the spouse, files an I-485 application together. And then you generally are going to be called in for an interview to show the validity of the marriage. Sometimes they are waiving the interviews for family-based even now. If the marriage is less than 2 years old at the time you receive the green card, you're only going to get a conditional green card that's valid for just 2 years. After 2 years, you have to file one more application, an I-751, to remove the conditions. At that point, you have to show that you're still married, that it was a valid marriage all along, and everybody's happy, and provide all the same kinds of documents to prove that valid marriage. Once that's approved, then it's a permanent green card. So that's kind of how that immediate relative category works.
Got it. That's great information. I see I see a caller here, Emily. Probably we can take the question. This is for caller ending with 2799.
Hello, good evening. I have traveled using my AP after my H1 approval, but I don't see, when I'm returning back from cruise, they didn't see anything other than they just scanned, biometric scan as passport. They didn't have any documentation verified. My I-94 is not updated online, though it was approved until 2025. What are my, actions should I take at this time?
So you got your H-1B extension approved till 2025, and then you traveled and came back on AP, and you said that was on a cruise?
Yes, I traveled using AP on a cruise, but on the return, they didn't verify anything. Just they scanned us biometrically. Basically, they're verifying the passport.
Was it a closed loop cruise that technically never left the U.S.?
I don't know if it is a closed loop or not, but it is Bahamas.
Bahamas, okay. All right. So you can contact deferred inspection of CBP. There are several of the locations that have email addresses, and you can send them an email with your entrance details, the cruise information, and passport details, and ask them to issue an I-94 if one wasn't issued, so that you can get that printed showing your valid entry on the advanced parole. That would be probably the best place to start, is one of the, and you can choose any deferred inspection office. So if the one that's nearest to you does not use the email address, you can choose another one and just contact them by email and see if they're able to rectify it. Otherwise, you might have to go into deferred inspection to get them to correct it, but most of the time it can be done by email.
Do you think this delay, will there be any delay in updating the I-94 online, or is this abnormal?
No, nowadays it's pretty much instantaneous. How long ago did you enter?
A week back.
Okay, yeah, it should have been updated by now. So most likely it's possible that they just missed issuing the I-94, which does happen from time to time, so I would reach out to deferred inspection.
Is there any specific location do you suggest, or should I get the email from online?
Yeah, emails are online, so if you just Google CBP deferred inspection sites, you'll get a list of all of them nationwide, and they have all of their contact information, and you can go through each one that to see which ones have email addresses versus which ones require you to go in person.
So do I need to worry anything about this missing information?
No, I would not worry about it. Just keep documentation of your cruise itinerary and the date that you entered.
Okay, great. Thank you so much.
Yep.
Bye.
Thank you so much. Thank you so much. And Emily, that was the last caller for the day. And really appreciate the service that you and the firm is doing in this whole regards and helping whole immigration community at large. Thank you so much.
Yeah, so happy to be here. Glad to be able to help answer some questions and hope everyone has a great rest of their weekend.
Thank you so much. And this is for everyone out there. Have a wonderful rest of the day and thank you.
మీకోసం ఒక అద్భుతమైన జ్యువెలరీ కొనుగోలు అనుభవం ఎదురుచూస్తోంది. మలబార్ గోల్డ్ అండ్ డైమండ్స్ వారి డాలస్ షోరూమ్ లో 20 దేశాల నుంచి 30,000 విధాల ప్రపంచంలోకెల్లా ఉత్తమమైన జ్యువెలరీ డిజైన్ల అనుభవాన్ని పొందండి. $1,000లకు మించిన డైమండ్స్ అండ్ ప్రెషియస్ జెమ్ జ్యువెలరీ ఆభరణాల కొనుగోలుపై ఖచ్చితంగా పొందండి బంగారు నాణేలు. జనవరి 29 వరకు మలబార్ గోల్డ్ అండ్ డైమండ్స్ ని డాలస్ లో విజిట్ చేయండి. ప్రపంచ స్థాయి జ్యువెలరీని కొనుగోలు చేసే అనుభవాన్ని పొందండి. Malabar Gold and Diamonds now open in Dallas.
గెలుపే ఊపిరిగా, పట్టుదలే ప్రాణంగా, ఆశయమే గమ్యంగా పోరాడే యోధుడికి విజయం అన్స్టాపబుల్. ప్రశ్నల్లో మరింత ఫైర్, సర్దాల్లో మరింత సెటైర్, మీకోసం మరింత రంజుగా. దెబ్బకి థింకింగ్ మారిపోవాలా? మీకోసం మరింత రంజుగా.
अब तू देख लेगा बच्चन साहब का खेल।
Download AHA now.
ఆకర్షణీయమైన చీరలు